to your presenter. You may begin.
Good afternoon, everybody. It's Chris Valentino of Jackson Lewis. I hope everybody's having a great summer. It was great to see so many people come out for the final sessions of the 2016-2017 breakfast series, both in Riverhead and Melville. It was sort of record-breaking year for us. And I know SHRM was thrilled, and certainly Jackson Lewis was thrilled. So thank you so much for your participation and support of the breakfast series. It's something that we love to do, and we certainly love that it's well received by the Long Island HR community. So what I wanted to do today was talk to you about a development in the law that probably doesn't apply to most of the people who are on the phone, okay? But I want you to see it as a direction of labor and employment law that everybody in the HR community needs to be aware of. There is significant changes, seismic changes taking place in the way that the employer and the employees do business with each other. I'm sure everybody has heard the phrase the gig economy, right? We are moving very rapidly in a direction of having a very transient workforce. Some predictors are in 10 years, better than 50% of our workforce will be temporary workers, people working in remote locations, people who are contractors, i.e. The people who are working within the gig economy. So the world is changing, and statutes are going to be changing with it. And when the statutes change, the burdens and the expectations of HR and the employer community will also change. One of those trends that is, I think, an offshoot of the changes that we are seeing now and more to come deals with predictive scheduling. This is a concept that applies mainly to the retail world, all right? In New York right now, only in New York City, but, we'll see what happens in Albany. It only deals with the fast food industry. But I wanted to spend a little bit of time talking about it today as a trend that I want all of the HR people that I deal with as clients and also within SHRM Long Island, I want them to be aware of this, right? What is it? Predictive scheduling. It is the setting of the work hours that do not vary from week to week, okay? It is giving employees more notice of their work schedules and when those schedules may ultimately change, right? And what it also is, in addition to making sure that employees know their work, i.e. giving them advance notice, making sure employees don't have their schedules change, at least the New York City law and other laws that are emerging in the United States on predictive scheduling, they add a lot of additional issues, which include ensuring that employees have a sufficient amount of time, turnaround time between shifts, making it so that employers cannot give available hours of work to new employees, but must first offer those hours to existing part-time employees, right? Making sure that employers don't saddle employees with the burden of finding their own replacements. Okay, a lot of these different adjustments in the way that the employer-employee relationship is, taking form are being made in these predictive scheduling statutes. It's not just New York City. There are a number of states right now that have predictive scheduling laws. Those states include, well, cities and states. The San Francisco ordinance has been around for about 2 years. Seattle just passed its own predictive scheduling law. There are about 10 to 12 states right now that are considering state laws in this area. And those states include California, Connecticut, Illinois, Indiana, Maine, Maryland, Massachusetts, Minnesota, Oregon, and Washington. Okay, so predictive scheduling, I want you to be thinking retail establishment likely will extend out to service, but a strong indication of where the employer-employee relationship is going. Statutes providing employees with greater rights to work and to compensation, right? So in the slides, as you can see, we, opponents of this initiative, this movement, call it restrictive scheduling. What is this statute really doing? What it is cutting down on an employer's ability to have a flexible workplace in order to maximize its profits and minimize its inefficiencies in terms of staffing, right? It's flexible. It allows employers to make last-minute changes depending on a whole host of different things, including customer trends, traffic, weather, season, things like that. The ramp-up time, for the seasons, if it's not as trafficked as you think it might be, and cutting back on your staff will ultimately result in penalties being paid by the employer. Okay, critics argue that an unstable work schedule prevents employees from receiving a steady flow of income. This is a kick out of the Obama administration, right? This is pushing more people into the middle class, making sure that the low wage earner has guarantees and expectations in terms of income, in terms of the ability to manage a lifestyle issue, whether it's transportation, whether it's childcare, whether it's elder care. Right. So people who are moving and proponents of predictive scheduling, it's all coming from the same initiatives that we saw out of the Obama administration, dealing with overtime regulations, making sure that that salary base is increased. What did that do? The goal was to push more people into middle class, right? The NLRB, the quickie elections, push more people into the middle class. Well, this is a distant cousin of those laws. As I alluded to, San Francisco has its own law. Seattle has just passed one. New York City has its own law. You may remember when the Attorney General of New York sent out a letter to all big retailers in New York City 2 years ago, which included Target, included Walmart, included all these big stores, basically saying you got to stop changing employee schedules because you're killing the service worker. He followed that up in 2016 along with several other attorney generals from about 5 or 6 or actually 7 different states requesting information from these national retailers about how they do their scheduling. So New York is certainly leading the way in this area. Our law here in New York, which is New York City, again, for Long Island, it doesn't apply, quote unquote, yet until Albany, starts moving on this. But for the time being, it's not something we need to worry about, but we need to watch it, unless, of course, you have New York City operations. And what does it do? It becomes effective at the end of November, and it is, again, it's narrow to fast food employees. It requires advanced notice of somebody's schedule. It requires that if you make changes to that schedule, it must be more than 2 weeks in advance. A failure to provide the employee with 2 weeks advance of a change in the schedule will result in the employer having to pay a penalty to the employee for the change. And those penalties vary. If the change does not take hours away from the employee, and is made between 14 and 17 days, 14 and 7 days before the employee actually works that shift, i.e., I say, to my employee, Chris, I don't need you to come in from 9 to 5 tomorrow. I need you to come in from 10 to 6. I haven't taken hours away from that employee. What I've done is change the shift. The penalty there if that change is made between 14 and 7 days before the shift, would be something as simple as a $10 penalty, right up to the fact that if that employer says to me within 24 hours, I don't need you tomorrow, the penalty would be $75. So you could see that the New York law is very penal in this area. You do not in New York, as in the industry that it applies, you do not have the ability to offer new hours, available hours to new employees. What you need to do is take available hours and offer them to existing part-time employees so that you can fill their cups. So whether it's right or wrong, what the New York City law is intending to do is make sure that employers cannot artificially keep employees below a certain level to keep them from receiving benefits, whether it be fringe benefits under a handbook, vacation, sick, and personal, whether it be retirement benefits or health benefits. Keeping them below a certain level to artificially keep costs down is the focus of the New York City law. New York City also basically says, look, what we want to do is we want to eliminate the possibility that you are going to have an employee close the shop and open it the next morning without a sufficient turnaround. They call it clopenings. No clopenings, prohibit them, provided that the employee has at least an 11-hour turnaround. So, again, you see New York City infiltrating its way into the employer, the previous free market of the employer-employee relationship. Okay. In terms of the retail industry, the slide that you're looking at now is a proposed law that talks about, and this is not into effect, again, just proposed, is talking about, for all of retail, making that a 72-hour notice provision, making sure that employers don't change employee schedules more than 72 hours or less than 72 hours in advance of the shift actually being worked. In addition, what is also being proposed in New York is a flexibility law. In New York City, is a flexibility law that would allow employees the ability to come forward and ask their employer for lifestyle changes to their schedule. The New York City proposals with regard to the retail world adds also a very interesting concept, and that concept is borrowed from disability and religious accommodation laws. What's being proposed in New York City on a broad level is a statute that will allow an employee the right to come to the employer and say, I need a flexible work schedule because of my lifestyle. And in the event that this law passes, and in the event an employee comes forward and requests that flexible schedule, an employer will have an obligation to engage in the interactive process to determine whether an accommodation can be made for this employee's life schedule, right? So this is huge. This is sea change stuff, again, proposed, but it will be interesting. We have to watch this. We have to see what's going on. At least for purposes of today's call, know that the only thing that we really need to worry about right now is in November in New York City, fast food predictive scheduling is going into effect. Accompanying these laws include record-keeping and enforcement requirements. Affected employees will have a private right of action in the event that employees or employer violates the predictive scheduling law. There'll be a 2-year statute of limitations. In addition to the penalties listed, there will also be compensatory damages. And yes, there will be reasonable attorney's fees that can be regained by employer violations here that ultimately will make this law much more attractive to plaintiffs' attorneys who want to bring claims. The New York City Corporate Council may commence a civil action on its own where it believes that there's a pattern or practice of violations. All right. What should a New York City employer do right now? You need to be adjusting and getting prepared for compliance with the predictive scheduling law that will go into effect, even if you are not a New York City employer. Even if you're not a retail or fast food employer, if you are retail, quasi-retail service, please understand that this is almost like the ban the box from 3 years ago, right? Once one jurisdiction put it in place, other jurisdictions copycatted, and they expanded it. I see this as being the next big trend with predictive scheduling. So be on the lookout for it. How can we apply for it now, or how can we adjust for it now? Critically look at how you're using on-call people. Do you use them? To what capacity? If you are using them in a significant capacity and your on-call people are really considered part-time or full-time, understand that when this law goes into effect, if it goes into effect on a state level, you're probably going to be precluded or greatly deterred from doing this. So you want to maybe think about how you're handling on-call employees. You want to look at your payroll practices, certainly look at your scheduling procedures, your internal scheduling policies. And as always, you want to be reviewing your scheduling for and the implications of your scheduling for wage hour compliance. All right, just a very, very quick update. If you hadn't heard, the paid family leave final regulations went into effect on July 19th. They were passed. We saw them. Were there a couple of changes included from the proposed regulations that came out in February? The answer is yes. Specifically, employers must offer the option to waive out of PFL coverage if the employee will not be eligible for the benefits. That's a change because now the employer has the onus of identifying, who will not be eligible and then ultimately offering the option to waive out. I've had this question come up several times, and I'll talk to you about it today. What if you have an employee who gives birth in 2017? And let's just assume for a second that birth takes place in August of 2017. If you are an FMLA employer, you have an obligation to provide 12 weeks of FMLA. Let's assume that you do that, August to September to October to November. Employee is out from middle of August to the middle of November on FMLA. The paid family leave in New York provides employees with 8 weeks of paid leave for bonding, and that comes into effect in January of 18. All right, there is no obligation that they work a certain number of hours, right? That is specific to the FMLA. So in theory, an employee who goes out on 12 weeks of FMLA in 2017 for, serious health condition, i.e. pregnancy for 6 weeks or 8 weeks, and then rolling that out with an additional 6 or 4 weeks of bonding, will now be eligible for an additional 8 weeks of bonding come January 1st. Not only that, but then we'll get paid for that time. So for the birth of a child, depending on the timing of that birth, you could be looking at 20 weeks of leave, 8 weeks of which are paid, as this law rolls into effect in 2018. So stay focused on that. And if you have any questions about paid family leave, if you have any questions about the application of it, updating your policies, as SEAM issues come up, do not hesitate. Reach out to me, shoot me an email, give me a call, whatever it is, we'll be happy to help you. Have a great rest of the summer, and we will speak to you in August. Bye-bye.